Hi, everyone. Welcome. I am so glad that you are able to join us this evening for another installment of our winter session of Beyond the Walls, a partnership between the Oshawa Public Libraries and the Faculty of Social Science and Humanities at Ontario Tech University. I would like to start our evening together tonight with a land acknowledgement. We are thankful to be welcome on these lands in friendship. The lands we are situated on are covered by the Williams Treaties and are the traditional territory of the Mississaugas, a branch of the Greater Anishinaabe Nation, including Algonquin, Ojibwe, Odawa, and Potawatomi. These lands remain home to many Indigenous nations and peoples. We acknowledge this land out of respect for the Indigenous nations who have cared for Turtle Island, also called North America, from before the arrival of settler peoples until this day. Most importantly, we acknowledge that the history of these lands has been tainted by poor treatment and a lack of friendship with the First Nations who call them home. This history is something we are all affected by because we are all treaty people in Canada. We all have a shared history to reflect on, and each of us is affected by this history in different ways. Our past defines our present, but if we move forward as friends and allies, then it does not have to define our future. Our practice in these events is to turn our attention to our guest speaker, who will speak for 20 to 30 minutes. And so during that time, we would appreciate it if everyone could please keep themselves on mute. We follow this with the remainder of the time dedicated to your questions in our discussion. And you are welcome to unmute yourself to participate, or you can put your question and comments into the chat. And now I am so delighted to introduce my colleague, Dr. Thomas McMorrow from Ontario Tech University's Legal Studies program, who is here to walk us through defining the constitutional limits to governing badly.
Great. Thank you so much, Andrea, for that great introduction and very fine land acknowledgement. I want to thank also Karen Crawley and Jennifer Gardner and Jennifer Clark for their help in putting this all together. I'm really excited to be participating in this event. The Beyond the Wall series has been excellent, and I know has been a great source of insight and inspiration, and even a certain degree of remote companionship during these difficult COVID times. You know, there's certainly always opportunity for an off night. And anyway, I'm glad that you guys are bearing with me here this evening. As the title of my presentation states, the topic is defining the constitutional limits to governing badly. And I'm going to be talking about that notion in relation to a current case that is coming before the Supreme Court of Canada next month. And that's the case of the City of Toronto and the Attorney General of Ontario. And it concerns a constitutional challenge to a law that was passed in 2018. And that law changed the ward boundaries in the midst of the Toronto municipal election. And so instead of 47 wards, it was cut nearly in half. And that left candidates scrambling because now they weren't running in the same wards. It confused voters. It certainly made things difficult for the City of Toronto clerk, who had the unenviable task of trying to switch the electoral format halfway through the process. But insofar as this case will give us a glimpse at the way in which courts in the past and the way in which the courts, as this case has been making its way up to the Supreme Court, have dealt with the question of, well, what are the limits to governing badly? When is an unfair law unconstitutional? I'll be looking at those questions, but really fundamentally what I'm interested in is not just the constitutional limits to governing badly, but the constitutional limits to governing well. And I think that that really is the most important question And what I'm going to try and do in the course of this talk is give you an overview of that case and the arguments for and against the unconstitutionality of the Better Local Government Act. But I also then want to consider this question of the legalization of politics. What happens when we treat political questions as questions of constitutional rights, not ones that our democratic representatives grapple with, but ones that we expect courts to decide on our behalf? So I'm going to express a note of caution about expecting too much from the Supreme Court in this case. And I want to draw attention to the fact that the challenges of governance and the political problems that we face in this province are a lot greater and more complex than would necessarily be captured in the terms of this particular case, or indeed solved by any remedy the Supreme Court of Canada could supply in its decision on this case. And instead, I think that what we need to do is to think about the Constitution more broadly, not just something that is defined by written text, but nor something that is simply defined by court decisions, that it's really a responsibility on behalf of all Canadians, and in this instance, all Ontarians, to expect of their government a certain level of performance, of commitment, and of principle. So I'll return to that as I go through. But what I'd like to start with right now is just by giving some background to the Better Local Government Act. So as I mentioned, it was in 2018, not long after the Ford government came into power. If you recall, they were elected in June of that year. And by August, they had passed this law that, to the surprise of a great many people, especially candidates in the municipal election that year, which would cut the number of wards effectively in half. And this was particularly surprising, well, for a few reasons. Obviously, the timing of it, right? So the writ had been dropped a couple months into the campaign, and all of a sudden, the ward boundaries were being redrawn. And so what that meant was that, candidates who had been knocking door to door at the homes of constituents found out that actually those people weren't eligible to vote for them at all because the boundaries on the map had been redrawn. So this idea that the political message they'd been trying to communicate had actually been wasted, and concern too that the electors wouldn't know for whom they should vote or how exactly to most effectively exercise their franchise. There was also concern that the particular wards that the government had imposed were now larger. And so what the government did, the government of Ontario, was they brought the wards to be on parity with the provincial and federal electoral districts. But the effect of this, of course, was that now you would have a municipal councillor for each ward representing a much larger number of people. And so there were understandably a number of objections to the timing of this law and what it was doing. And it was challenged by the city and challenged by candidates in the courts. And they said, this is unconstitutional. And in their argument that it was unconstitutional, they invoked the unwritten constitutional principle of democracy. So in the late 1990s, actually in a case, a reference case by the Supreme Court of Canada regarding basically the constitutional rules of Quebec secession, the court in 1998 talked about how there are a number of unwritten constitutional principles that are the very lifeblood of the Constitution. So even though they're not spelled out in the Charter, they're not laid out in the Constitution Act or originally in the British North America Act of 1867, which allocates powers between federal and provincial levels of government. But these principles are fundamental. And the court said, on the basis of these principles, we can say that, yes, the government of Canada needs to pay attention and needs to negotiate if Quebec has a referendum in favor of separation. But likewise, Quebec can't just unilaterally separate. They need to negotiate with the government, and there needs to be some kind of political way to work out the new constitutional arrangement, even if that includes secession. So it was an extraordinary situation because it was this hypothetical case that the Supreme Court was being presented with. And in it, they elaborated these unwritten constitutional principles. But also they said that these constitutional principles can be invoked to constrain government action. And so part of what the city of Toronto argued was that in this instance, this undermining of the electoral process by changing the rules halfway through the campaign was an attack on this unwritten constitutional principle of democracy. At the same time, they argued that it was a infringement of the Section 2B under the Charter, freedom of expression rights of the candidates and the electors. And so it may seem perhaps a bit counterintuitive that this would be a case involving freedom of expression. Because if anything, you might say, well, wouldn't it have to do with the right to vote, which is protected under Section 3 of the Canadian Charter of Rights and Freedoms. But under the Canadian Charter of Rights and Freedoms, Section 3 refers explicitly to provincial and federal elections. It doesn't mention municipal elections. And what's more, municipalities are not recognized as a constitutional order of government. So going back to that British North America Act, that imperial British statute, which established the Dominion of Canada in 1867, it allocates powers to the federal parliament and provincial parliaments, provincial legislatures, but it says that municipalities or cities are under the authority of provinces. So all that is to say, when this case came before the Superior Court of Ontario, Mr. Justice Bellababa said, this is an infringement of the freedom of expression of these candidates and of the electors, and the government's provided no good reason why they would infringe on their rights in this case. And so because of that, they don't, satisfy this threshold which governments have for infringing rights, which is that the infringement be demonstrably justified in a free and democratic society. So Justice Bellababa said, hold the press. The election is going to proceed according to the old ward structure. And when he handed down that decision, Premier Ford reacted very strongly and said, well, we're going to invoke the notwithstanding clause. So another kind of piece of Canadian constitutional trivia, and I'm sure many of you are familiar with it, but under Section 33, there is a possibility for legislatures to basically invoke a rule that says that the legislation they're passing will not be invalidated by courts for violating certain rights under the Charter. And this was a clause that was included in the Constitution Act in 1982 because it was felt that, well, if we establish a Charter of Rights and we give courts this kind of power to invalidate legislation, then we might undermine our existing democratic institutions. So we'll create the Section 33, the notwithstanding clause, so governments can pass laws notwithstanding the fact that they infringe on charter rights. And that will ensure a bit more balance in the constitutional system. Now, no Ontario Premier had ever invoked the notwithstanding clause. And indeed, in the end, Premier Ford and the provincial government of Ontario did not end up invoking the notwithstanding clause either, but he threatened to do so. And instead, what they did was they appealed the decision, and time was of the essence because the election was coming up, and the Ontario Court of Appeal basically said, well, we'll have to determine this on the merits at a later date, but in the meantime, we don't think there's a strong enough case here for the city of Toronto, and so we're going to reverse that decision of the Superior Court, and the election's going to go ahead with this new ward structure. And so it did in 2018, fall of 2018. Toronto City Council comprised 25 instead of 47 wards. The next year, the Ontario Court of Appeal laid down its decision confirming its original ruling. But in this case, there were 3 members of the court who said that the law was constitutional and 2 members who said it wasn't. And those 2 members of the court who said it wasn't picked up on where Justice Belobaba had argued that it was an unjustifiable infringement of the freedom of expression of the parties. Now, as much as one may think that the Better Local Government Act is a misnomer, there's also a case to be made why it is nevertheless constitutional. So, on the one hand, the sense of injustice and unfairness that people felt when this law was passed was that local democracy should be respected. And so there just seemed to be something deeply unseemly, indeed, the City of Toronto argued unconstitutional, about disrupting an election, about interfering with the electoral process. And there's a sense as well that, okay, yeah, maybe the British North America Act in 1867 didn't allocate lawmaking power to municipalities. And maybe the Canadian Charter of Rights and Freedoms in 1982 under Section 3 didn't explicitly acknowledge the right to vote of, as it pertains to municipalities, and only mentioned it in terms of the parliament and provincial legislatures. We know that, over the last 150 years, and certainly even under the last 40 years, that municipalities, especially big municipalities like Toronto, play an incredibly important role in people's lives. They may formally be creatures of provincial statute, but they're lawmakers in their own right. They collect taxes and they develop policies and provide services that are a huge way, that have a huge impact on people's day-to-day experiences. And so to treat the capacity to participate in these forms of local democracy as just something that can be added or taken away at whim, understandably upsets people, and understandably gives rise to a sense that surely, even if there isn't a formal rule against this, that the unwritten principles of the Constitution, for example, these commitments to democracy and the rule of law, ought to prevent the provincial government from proceeding in this way. But there's a challenge, right? Because if you think about the Supreme Court accepting that argument, then effectively, in invalidating this law, they would declare municipalities a third order of government. And what would that mean? And how can a case that involves the City of Toronto give rise to a decision that would potentially affect a whole number of municipalities across the province? Very different in size, very different in scope, not to mention the rest of the country. And what would the knock-on ramifications, the political effects of that kind of recognition be? What, for example, would happen if Montreal were regarded as a municipality with its own constitutional authority? What would its relationship to the province of Quebec be as a result? And what would it mean for national politics if Montreal weren't part of Quebec in the same way it is right now? Montreal being, of course, the place in Quebec with the highest number of Anglophones, the highest rate of social and religious diversity in that province. So there's a number of complex questions, a whole number of parties whom this decision would affect, who don't get to have their say, who don't get to have their day in court. And so there's a question about whether, okay, yes, maybe Canada's constitutional order, insofar as the rights of municipalities and authority of municipalities go, is outmoded. But are the courts and is constitutional adjudication the best way to remedy the problem? And I think that we need to be mindful, right, about thinking that courts can provide the answer here. Because there's a danger of what I mentioned at the beginning of my presentation about the legalization of politics. And that's where we convert political questions of how do we govern our lives together, as legal issues, which courts are best suited to addressing and solving. And there can be something very disempowering about this, right? Because if you don't have the expertise or the credentials or the money or the influence to partake in the litigation process. In other words, if you're not a judge and you're not a lawyer and you don't have the money to hire one, then what are the opportunities for political engagement that you have if politics is reduced to the judicial process and to litigation before the Supreme Court of Canada. There's another problem too, is that if within our political vocabulary, our focus is strictly on rights, then we may not accurately describe and name the way in which government is failing us. So as I mentioned, we can appreciate why a disruption to the electoral process signifies an undermining of democracy. It's certainly disrespectful to local democracy. But is it automatically an infringement of the freedom of expression? So what happens when we think about a disruption to a political system, to local democracy, strictly in terms of the individual rights of voters or the individual rights of those who are seeking to represent them? We necessarily kind of miss the bigger picture, and we have less of an appreciation of the complexity and indeed the scale of the problem with acting in a way that's so disrespectful of the democratic system and of the electoral process. And so the other way in which I think it's problematic to be preoccupied or to focus solely on rights is that when we look at the Canadian Charter of Rights and Freedoms, it protects civil and political rights. And that's how the courts have interpreted it. So in other words, social and economic rights, which are fundamental to a person's existence, are nevertheless not deemed of constitutionally enforceable status within our system. So to the extent that we see everything that matters to us in a constitutional sense just through the lens of the Charter and just through the lens of court adjudication, it means that we're already ignoring things that can't be framed strictly in terms of civil and political rights. And so we need to remember also that courts are necessarily reactive in their design, right? They're there to adjudicate. They're not there to formulate policies. They're not there to develop or administer programs. If you like, in a way, they're like health inspectors, right? Who are making sure that the food has gotten onto your table in a particular way. But they're not cooks and they're not farmers, and they don't get to have a say in whether you have enough to eat or not, or at least they haven't taken on that role in our society. So understanding the limitations of courts is really important, lest we start to conflate the constitutional standards they set, the minimums that they set, as somehow adequate to having a healthy, just, and fair political system and political life, right? So what is the Supreme Court of Canada doing to stop rising sea levels? What is the Supreme Court of Canada doing in order to ensure that kids who have fallen behind during the last wave of lockdowns, being out of school, will have a chance to catch up on their learning? What is the Supreme Court doing to ensure that elders in long-term care facility are protected from the COVID virus and also have the supports they need? And I'm not saying that, oh gosh, look how bad the court is because it's not doing all those things. I'm just using those examples to show that, of course, there's limitations to what we can expect from courts. There's a reason why we have two other branches of government. Like my grandmother used to say, there's a reason why you have two ears and one mouth. There's a reason why we have two other branches of government, the executive and the legislature, precisely in order to perform these lawmaking and administrative tasks that courts are not designed nor operated to perform. And I think that there's two things which are worth paying attention to here. So the rise of right-wing politics globally has given rise to this sense of, okay, well, we need to stop politicians run amok. There needs to be a way for courts to stop politicians who seem not to have respect for the unwritten norms of a constitutional liberal democracy. And so it's quite understandable in an era where confidence and trust in politicians appears to be low, indeed, perhaps even confidence in the electorate is low, to hope that courts will be there to bail us out, to ensure that certain core principles are respected and defended. But another feature of our times right now, which is the pandemic, brings something else into relief, right? So in political discourse, we often hear public administration denigrated, right? We hear negative things about bureaucrats and public servants, and that can sometimes just actually be from people we know who actually work at Service Canada or public servants themselves. No, but we certainly, do not have a kind of political discourse that generally, extols the virtues of government bureaucracy. And yet, during the pandemic especially, it's really brought to the fore how the value of the efficacy and accountability of the public service is so obviously essential, right? So whether we're talking public health officials, election return officers, special investigative unit investigators, or hospital custodians, all of these people were paid by government, need to be decent, need to be hardworking, need to be trained, and need to be fairly compensated, because our system, based on the rule of law and the promises that we hope government can fulfill to Canadians, depend on people doing their jobs and doing them well. And so, whether we're talking about short-term measures like lockdowns, or behind the scenes ongoing processes like planning and budgeting for local public health authorities, we see that these aspects of administration, these perhaps more mundane features of lawmaking, are indeed matters of life and death. And so, as important as the courts are, and as important as it is to enforce constitutional rules, it's important to recognize also that they're intrinsically limited in their capacity to ensure not just that we avoid the worst pathologies of bad governance, but that we're able to achieve the kind of level of good governance we need to address all of these complex issues that we face, pandemic or not. And so, what I will kind of end with here is just to think about the fundamental constitutional challenge as not just one of being how to curtail abuses of power, right? How to place checks on the power of the legislature to pass laws. Because we have to think that, well, in order to meet these persistent and complex governance challenges, the provincial legislatures and parliaments also need to be able to have power, right? And so we need to be mindful of how the desire to see someone have their reckoning with consequences we think that they should have paid more attention to may in the end do more harm to the institutions that exist in this fine balance, and that ultimately the genuine accountability that politicians need to have in order to ensure that they're discharging their duties in an effective way can't just be to courts, and can't just be out of fear that 4 years or 3 years down the road after they've passed a law that there could be a hearing before the Supreme Court, and a whole other year perhaps after that before that initial legislation is invalidated. So I sympathize indeed with those who are challenging the Better Local Government Act. On the other hand, I think that perhaps, they can be heartened that if they do indeed lose before the Supreme Court of Canada in this appeal, that perhaps that will provide the level of motivation that Ontarians and perhaps others throughout the country will need in order to pursue through constitutional politics the kind of renovation of Canada's formal constitutional order that can ensure that these forms of local democracy get the respect that they deserve. So I will conclude there, and I look forward to your questions. Thank you.
Thanks so much, Tom. That was fascinating. I would love to turn the floor over to those of you joining us so we can pick Tom's brain and learn some more.
I have a quick question. Tom, thank you very much for that really rich discussion. And my question is not going to do it justice, but I was really interested in the way you talked about limitations, the limitations of the approach that this particular case is compelled to make because of the system that we work in. I'm particularly interested in what you had to say about how a singular focus on rights leads to a kind of myopia about the political shortcomings of our constitutional system. And then complementary to that, you talked about limitations of the courts. And I thought the metaphor of a health inspector was just beautiful. It really revealed it really lays bare the way in which we can't expect courts to be policymakers, although sometimes critiques of the court's activism, as it's often described from some parts of the political spectrum. There's a story about courts, how they can be activist, that suggests that they are policymakers. But in fact, I think that the discussion that you just gave us talks about the way, helps us to understand how that's not possible. Courts really are just applying the regulations. And I'd like to invite you to say a little bit more about the way in which you think that those political shortcomings might be remedied.
Okay, well, I'm glad I arranged Natalie to lob me a few of these slow pitches, these easy questions. Well, first of all, I think thinking about rights, and in fact, thinking about rights or thinking about the relationship between courts and legislatures, I will confess that there's a danger to making wide generalizations, right? Like I don't think that there is any necessarily ideal institutional arrangement or even ideal concept in law. There's a tremendous amount of contingency to all of these things, right? And to lament or criticize the way in which rights discourse can impoverish our lives, all you need to do is look at the experiences of people who fought for their rights. And were it not for constitutional courts recognizing their right, whether as women or whether as racialized minorities or any number of people in our society who have felt that they've really had to fight for their rights. So I'm very cognizant of that. And what I'm saying though is that that's just one concept. And that's just one word within this larger legal vocabulary. And it can be helpful, and it can draw our attention to questions of injustice that we might otherwise overlook. And indeed, part of the job of being a lawyer is being able to deploy that language of rights to show how an issue actually affects somebody's rights. But it also means that you can do that in any number of cases. In fact, I would say every example of a political decision or a managerial move that you've experienced, even just in your place of work or an unfair experience you've had in a classroom, you can reformulate that as a question of rights. And we see that in this case where the disruption of the municipal election is reframed as an infringement on the rights of candidates. And I just don't think that is the most accurate account of the injustice that's transpired here. And I don't think that in responding, like the vindication of candidates to have not had to knock on too many doors without having those people, able to vote for them, just doesn't do justice to what's problematic with disrupting an election in that way. The fact is part of the concern is that, well, by stripping the number of wards, by cutting them in half, it means that there's fewer opportunities for candidates to run. And so what happens? Well, it tends to be that then the incumbents win. And if you look at the composition of the Toronto, Municipal Council, it's not at all reflective of the diversity of the city of Toronto. And all of, the more competition for fewer seats isn't going to change that. But it doesn't mean that you can necessarily highlight all those problems by explaining them in terms of one individual's right to be a municipal councillor, because nobody does have a right to be municipal councillor. And I think that to the, one of the arguments that that those who are critical of the law and who say it's unconscionable give is like, well, if there's no limits, does that mean that the government could then pass a law that says that the day after the election, it's not the elected mayor who in fact becomes mayor, but somebody of the premier's own personal choosing, and I think that, yeah, in that case, that would be alarming. And maybe that's a case where then the courts would say, look, this is highly unusual and it's an extraordinary circumstance, but we're going to need to interfere here. The thing is that I don't think that a government acting in a way, even that's obtuse, is all that extraordinary. Or at least I think that it would be extraordinary for us to expect the courts to demand an ordinary level of competence and accountability and wise decision-making by our elected officials. And so I think that when I'm talking about the needing to recognize the limitations of courts, it's to see that, the metaphor, I mean, the metaphor of trees is used so often, but one of, I think, the, if we think about how the branches on a tree, they are connected, right? And that the sign that one of the branches is withering could very well be a sign that the rest of the tree is unhealthy. And I think that what happens sometimes, due to the best of intentions, is that too much weight is placed on the judicial branch, when really it can't perform this kind of more review type role if people aren't doing the right things in the first place. And we think about all the different encounters we have with government, whether that's on a municipal level or whether that's provincial or federal. And you need good people in those jobs, and you need people who have a sense of responsibility and commitment to principle and to what we're doing as a society that doesn't depend on a court correcting them if they mess up. And so in thinking about, when I said I want to get from thinking about defining the limits to governing badly, the constitutional limits to governing badly, is thinking about what are the constitutional conditions to governing well. And I think part of that is seeing the way that beyond the court's role in enforcing a legal constitution is we need to renew the public's role and the role of our elected representatives in a political constitution.
Thanks, Tom.
Hannah, you are up next, please.
Hi, everyone. I'm not a lawyer, so a lot of this conversation kind of it was challenging for me. Because I was trying to wrap my head around the idea that, so why should I be concerned about this if, say, in Oshawa, where we are now, they just sort of rearrange the next government comes in and they want to put it in their favor, so they know if they rearrange things again, they've got precedent already set in Toronto. And as you said, municipalities aren't really controlled by this. And then I was thinking about the idea of the food inspector, right, or the health inspector. I was sort of thinking about, when you started talking about the health inspector, is that each one of those ward people, the people who run those wards now, there's half as many of them, each of those were health inspectors rather than the court being the health inspector. And what happens when you cut the number of health inspectors for a city in half, right? It becomes more challenging to do the job. Is there a possibility that the courts could sort of acknowledge that the democracy as it had been shaped and cut in half couldn't actually address the concerns of its community? Is that, I'm not sure if I'm making any sense there, but it seems to me that coming in and just sweeping the board and cutting the number of people who could be eligible to vote, I don't know if it's unconstitutional or not, But there are certain people who do have rights within that family of people in Toronto who may not actually have the ability now because they can't access the people they need to make those challenges, even as a form of activism to the court, and say, hey, I'm going to challenge the court, and I'm going to bring the court along with me, and I'm going to force it to make a decision in here in this form of activism. I'd be the activist in that case, but I'd be using the court as a tool. So
yeah,
that makes any sense.
Yeah, no, that's a great question, Hannah. And I think what the whole notion of local democracy is predicated on the idea of having some connection to the people who represent us. And presumably, yeah, if Parliament only consisted of 10 people representing the entire country, would say, well, that's by definition less democratic than the current number of seats. And at the same time, though, that particular argument hasn't had traction with the courts in the past. So they'll say in Vancouver, for example, the city council is way smaller than the one in Toronto, and they say that there is no kind of absolute guarantee of a certain level of representation. But I mean, that's definitely an argument that I think we'll hear coming forward in some way, probably in that appeal next month. But I think it's also a good illustration of how there's the constitutional question, or what how can you, based on the text of the Constitution, based on precedent set in past cases, argue that a government didn't have the authority to make a decision. But then there's also the question of whether a government's making a good decision. And I think that for the the provincial government, in defense of their law, are saying, look, city council was dysfunctional, and by having fewer councillors, this allows people to get down to business. Now, there was all sorts of stuff when this, if you Google the 2018 local, Better Local Government Act, where people are talking about the fact that the premier had himself been a city councillor, whose appreciation for the deliberations of that esteemed body were reflected in his attendance record, right? And so one of the things in the actual judgment of Justice Belobaba at first instance was that it would appear that there was a certain amount of pique with which the government was acting, because it wasn't clear, like, why do this now? But there's another law too that they've, in part of the legislation to address the effects of COVID on cities, is they have tried to make it, or will be making it, uniform that no city can adopt a ranked ballot, right? So a number of municipalities have adopted ranked ballots, the idea to enhancing proportional representation. But the government's view is that no, it would just be better if everyone, if it was the same, and for consistency. And likewise, the primary argument, one of the arguments for the Better Local Government Act's splitting of the number of wards as well, look, this is what the federal electoral districts are, so let's ensure that the cities are the same, even though, as you point out, we're talking municipal government and local issues, and so presumably you would want to have fewer people being represented. And then there's also questions too, and this is where it gets tricky as well, because some scholars would say, well, courts need to keep an eye on governments when it comes to redrawing electoral boundaries, because if it's clear that in interfering with electoral boundaries or an electoral process that it's very obvious that they're engaging in partisan self-dealing, well, then there needs to be a constitutional check on that. It's more difficult when the change seems to just kind of reflect an overall perspective or ideology of the party in power, and the fact that this is not an isolated case in terms of you have these other kinds of pieces of legislations being passed that address or that undermine local democratic decision making. But then you also have a whole bunch of other pieces of legislation, as I said earlier, that don't have to do with democratic rights, but have to do with, the fact that, Canada, or rather Ontario, the people who are living on the lowest income in the province have, either through government acts or omission, not seen their material circumstances change, and in many cases get worse. And yet we don't seem to be able to mobilize the same amount of energy and interest in addressing that in the same way that we have this.
Yeah. Thanks.
Yeah, agreed. Thank you for that detailed answer. Other questions that are not Natalie's? No offense to Natalie, of course. But if there's somebody else that wants to, all right, Jen, please take it away.
Jen, we can't hear you.
I was muted. This is a classic Zoom problem. You can hear me now? All right, I just thanked you, so we can skip over that part. I said great things. I was wondering whether I can probe probably the, maybe one of the reasons you started this paper, there's a kind of key implication to the decision, sort of irrespective of its legal reasoning. Like all the op-eds about this case had to do with this threat of the notwithstanding clause. And the clause will ensure sort of parliamentary or legislative supremacy. It's this tool that would enable governments to say that they have the final say, but it's like a wildly controversial tool that's so infrequently used that whenever politicians threaten to use it, we start worrying in legal scholarship about the potential of a constitutional crisis. And we're in a timeline where we didn't have to see it invoked, right? So Ford didn't have to use the notwithstanding clause. We weren't pushed to that limit. I guess I'm wondering, does that mean that like maybe we learned the wrong lesson? We were saved by the courts from sort of the bigger sort of political implication to a decision where the courts intervene and then the government asserts its supremacy? Do you think that, I don't know, there's now this still existing provision that haunts legal and political fights that we haven't sort of answered questions around yet?
Well, I think the, if we go back to the notwithstanding clause, there are a number of commentators who say, as I mentioned, the government of Ontario has never used it. And the government of Quebec has, and recently the government of Saskatchewan did. And that this is evidence that, it's a kind of tool of last resort, right? Like in case, you got to break the glass before you take it out kind of thing. And what's funny is that when you go back to the early 1980s, like we associate skepticism towards the Charter of Rights and Freedoms as something purely on the right end of the political spectrum. But a lot of vocal opponents and critics of the Charter were more on the left end of the political spectrum because they were precisely concerned with what a group of unelected judges who, all well-heeled and well-educated with, stocks and bonds would be making decisions that affect all Canadians as opposed to democratically elected legislatures. And what kind of effect would this have on the vitality of our democracy to cede this kind of power to these appointees of the government? And so I think that there are still, nowadays, although, there seems to be a kind of reflexive association with critiques of the Charter, with the political right and with invocation of the notwithstanding clauses necessarily, being something that populists or majoritarians invoke, not understanding that we live in a constitutional democracy and that democracy requires respect for individual rights and the judges are the best way to guarantee that. But I mean, I guess what I've been trying to show in this presentation is that that's not necessarily so. And I think that the fact that the notwithstanding clause was necessary in order to have the charter, have the Constitution patriated in the first place and have the charter adopted. That if anything, that since courts are not able to perform all the governance tasks we need to meet, then there necessarily has to be circumstances where courts acknowledge their own limitations. Because if courts have, and an interesting example of this is in 2014, there was this Senate secession reference. And in the Senate secession reference, the government of Canada under Stephen Harper referred this question to the Supreme Court and said, we'd like to start having elections for members of the Senate. And so certain scholars say, well, this is an example of political evolution of the Constitution. Why do we have an appointed Senate in the 21st century? This is a chance for the government to evolve the Constitution. And opponents said, what are you talking about? If you start having elections for the Senate, then you're going to radically change Canada's Constitution, because that will give the Senate more legitimacy. And now we've got two chambers, each with that kind of legitimacy. And this is going to change the role of the Senate from its position of being a chamber of sober second thought. And what the Supreme Court of Canada did in its decision is a University of Toronto Law Journal article that I was reading recently by a political scientist at McGill was talking about the way that the Supreme Court adopts this really, architectural language, this metaphor of structure, and this idea that the structure of the Constitution constrains the government of embarking on these kinds of changes by political convention, that really what they need to do is formally amend the Constitution to have this kind of change. And it kind of draws home that, like, some of these constitutional decisions and the reasoning that's elaborated for them can be because of the fact that the judges themselves maybe aren't too keen on the substantive wisdom of the policy or the law in question. But there's a problem with, I think, sometimes ruling, coming up with elaborate metaphors like the structure of the Canadian Constitution, when, constraining political conventions and constraining the ways in which we can involve the Constitution, not just the courts, but the public and our political representatives can also stop us from evolving the Constitution in more just ways. And so, in the case of the Ford threatening to invoke the notwithstanding clause, I think that what was problematic was what seemed to be the lack of careful deliberation, right? It's sort of like you can't, really, I was going to use some kind of vulgar example, because part of it is like, even with vulgarity, right? Like if you're going to swear, you don't want to it's context matters. And when you know that somebody understands the effect of what they are saying, that even when they break that rule, it has less of an impact than when it seems they're just doing it completely without regard or understanding for that convention. And so if there's an element of deliberateness involved, then there's going to be more flexibility. And I think that one of the what I find the most compelling criticism was that it just seemed like the government didn't care about these kinds of things. And I guess what I'm saying is that that's a real problem. That's a bigger problem than the court can solve for us. And because that pervades not just this one issue of these changes to the electoral structure of Toronto's municipal council in 2018, but this needs to give us pause for the range of issues about how we're dealing with the COVID pandemic, how we're going to go forward from that, all of these things. And you shouldn't have to know necessarily what the Supreme Court decided in Irwin Toy in 1989 about the scope of freedom of expression to be able to say that what happened in 2018 with the Better Local Government Act was a contradiction in terms. And I think that there's a real cost associated with over specializing and reifying our political discourse so that people feel like they're on the outside, when really these questions are affecting us all. And I think that that seeing the way in which things are only going to change if there is more of a hunger for them to change, that's the only way that we're going to see much of a difference.
That was really rich, Tom. Thank you. I'd follow up, but I yield to the group.
If we can be super zippy, I think we've got time for one more. Anybody have a nice, short and snappy question and answer?
I can be really zippy.
Are you sure?
Tom, thanks. This was an excellent presentation. Really enjoyed it. And yeah, I was thinking of good old Ralph Miliband and the state and capitalist society and his discussion of the judiciary, right? That basically is an arm of capitalism. And yet, you know, I guess and I grew up on Ralph Miliband in my earlier studies, but I should say that when it comes to judicial activism, I'm all for it if I agree with the verdict. You know, I mean, you have to be practical maybe about this. I understand your discussion of the division of powers, but maybe it just comes down to, you know, let's just get things done politically. And if this is the way it gets done, well, you know, we take it. What I think is interesting too, though, is this question of mega cities, which Toronto's becoming, and whether or not, yeah, they do now belong in a special political sphere. And does it make sense for a provincial government to tell Toronto what to do anymore? And I think that's a really interesting political question that's playing out. I don't know how if you feel there's an answer to that, or it's premature, I guess. But well, thank you for an excellent talk.
I think no, but I think that I think that is the question. You know, I think that and I don't think that the Supreme Court's going to be able to answer it. And I think so. Part of my, I mean, I get what you're saying, absolutely. And it's funny because Mark Tushnet, who's an American constitutional scholar, has this concept of what he calls constitutional hardball, right? And you know, America has all these examples. I mean, we see it on CNN or Fox News. I don't know how many Fox News viewers we have here tonight for this Oshawa Public Library event, but you know, constitutional hardball is where you ignore these conventions or pretend they don't exist or they don't apply to you. And the funny thing is that people who are engaged in constitutional hardball or their supporters never think of it as constitutional hardball. They're being clever, they're being sharp, they're serving, you know, their voters. And so, you know, it really depends on whether, yeah, you agree with the outcome or you're inclined to the view. And I think we need to be careful about that, because I think that, you know, one of the things I've tried to underscore is that, you know, as much as one might, you know, agree with an outcome or want to see a somebody who they think maybe has been reckless with the public trust that's been entrusted to them, you know, I think would be, you know, wise to remember another Englishman, Robert Bolt's play A Man for All Seasons, where the protagonist Thomas Moore is being chided for letting his enemies get away and hide under the protection of the law. And he says, well, I'd let them have protection of the law. I'd give the devil protection of the law for my own safety's sake. You know, and so I think that there is something within a constitutional order where, you know, you want to be willing to take your lumps to live to fight another day. And I think that there's a danger in a Supreme Court making a decision about recognition of municipalities and their constitutional authority, potentially hamstringing provinces in the name of curtailing abuses of power, but preventing them from perhaps providing the kinds of changes that ultimately would lead to a better, more protected municipal government structure. So I do think that it's I definitely think that it's a pressing issue, and not just for megacities, right? But for municipalities across the country. And I think that you know, it'll be dangerous, and it is dangerous for local democracy, for people to feel like they're losing those municipal institutions, you know, whether it's in Oshawa or Kawartha Lakes or what have you. So anyway, I guess we are out of time, but I want to thank you all, and thank you. Peter Stute is the Dean of our Faculty of Social Science and Humanities. It's great to have you here, Peter, and thanks to my colleagues for their questions, and thank you to all of you for coming out. And so I'll hand over to Andrea.
Yeah, I have nothing to add other than just one more thank you for everybody who joined us and your awesome questions and this great discussion. And I'm so glad we got a chance to do this. I look forward to seeing you all again at our next event in 2 weeks.
Good night. Thanks, everyone.